consent order that was entered into by the parties herein following the intervention of the Law Society of Kenya and the Kenya National Council of Human Rights. However, there is a substantive appeal that is still pending arising from the committal proceedings that were subject of the 52B application. In the spirit of alternative dispute resolution that is promoted by the Constitution of Kenya, this court has mentioned this matter several times in the hope of the parties coming to an agreement. The court even allowing religious leaders from various organizations to join in as mediators. We are told that the religious leaders are still carrying on their efforts of bringing the parties to an agreement. We are, however, concerned that no agreement has been fully reached, although a number of issues have been resolved. We appreciate the efforts that have been made by various parties to mediate. We are, however, concerned and disappointed at the slow pace with which the matter is proceeding. As long as this matter remains pending, doctors have not been able to go back to work because a return to work formula has not been agreed upon. The union, having provided a draft return to work formula that the respondents are ready to look at, but the Ministry of Health, which is the interested party, is hanging tough and appears to be no longer interested in negotiating. We note that the substantive issues concerning the dispute, which are the CBA and the return to work formula, are really substantive issues that should be for determination by the Labor Relations Court. That notwithstanding, in light of the urgency of the issues, the public interest element involved in this matter, and the fact that the poor Kenyans are suffering because of lack of proper medical facilities, we are ready to bend backwards and give mediation a chance even in this court. We appeal to all the parties, including the Ministry of Health, to be guided by the best interest of Kenyans and put aside their differences, their egos, and also give the religious leaders a chance to help bring a compromise and the resolution of this matter. We are now, therefore, giving the parties the final chance in this court to have a compromise in this matter recorded. We shall mention the matter tomorrow at 10 a.m. That is tomorrow, 14th March 2017 at 10 a.m. We urge the respective councils as officers of the court to prevail on their clients to have these matters resolved. Should the matter not be resolved by tomorrow, parties should note that this court will not mention the matter anymore, but will refer the matter to the Labor Relations Court that is still seized of the substantive issues. And therefore, and the court thereafter, this court thereafter will continue with the appeal subject of the committal proceedings that are before this court. That is the order that we have made.
Most obliged.
I've just been asked to let you know the religious leaders have called for a meeting right away. So we are going for a meeting right now, if my learned friends agree.
Thank you. For sure.